today is one of my favorite singers ever, Etta James. I love her. um, so unfortunately, she has a little bit of a celebrity estate story, so we had to add her on here.
Hey, Christina.
Hi, how are you?
Good. How are you? Thanks
Good.
for joining.
Yes, of course. Thanks for having me.
All right. So I've updated our audience that we're going to be talking about one of my favorite singers, Etta James. So if you want to lead, go ahead and tell us the facts.
Okay. So, Etta James was diagnosed. She had a couple of illnesses, um, and her husband of 41 years was not named her agent of her power of attorney. It was a son from a previous marriage that she had done in 2008. Mr. James was her son, and he was named as her agent. And when time came where she really became incapacitated and the agent needed to use the power of attorney, her husband kind of claimed that when she signed it, her capacity at that time was iffy, and therefore the power of attorney should be held to be invalid. So they were in court for many, many years over this. Do they uphold the power of attorney? Do they not? Do they appoint a guardian? Or she lived in California, so they considered a conservator. Here in New York, it's a guardian. This case was a little bit different also because the husband also decided to sue under the community spouse rule in California, which said that he was asking that her money be considered his money as the community spouse, and that way he could use it that way for her. After several years of in and out of court, they finally settled where they would allow the husband to use about $350,000 a year for her medical care. So this really goes to show the importance of getting your estate planning done early on instead of waiting until, it's too late, or waiting to an age where somebody could call your mental capacity into question. I had a client the other day who, I guess they were in their 40s. And when I mentioned power of attorney, they were like, oh, I don't need that. We're not old enough yet. And I said, no, you need it now. Unfortunately, anything can happen. A young person can become ill. They can be in an accident. They can have a stroke, and may need it. So really with hers is, she got diagnosed at a very young age. And I believe she passed at around the age of 72. So she was young when she got she had leukemia, and I think she had onset of Alzheimer's. So she waited too long, and her mental capacity did get questioned, and it cost her family a lot in legal fees and time. Where if she would have done this in her 30s or 40s, it would have never been called into question because, then they would have known for certain that she had capacity to sign.
Right. Yeah. I mean, we don't know obviously what the son's intentions were or what the husband's intentions were, and from what we can tell, they both wanted the money to take care of her. I think the son was concerned about how much they were trying to spend and how much, the husband was willing to spend for her, or just him able to hack access with no restraints was a concern. And maybe the son was concerned because obviously that's his inheritance. So there's a lot of questions on both sides. But yeah, Christina, having a 40-year-old client doing a power of attorney, as you mentioned, is the way to go, because she could have done it in her 40s. She could have redone it again when, if there were updated forms in her 50s, 60s. If she kept naming her son over and over again, there's no dispute that she wanted her son to be in charge of the finances. But because we only see one document ever drafted, it's unclear whether he could have manipulated it or not. So yeah, this is a tricky case, and it's sad for the family. It looks like they were able to resolve it eventually, but I'm sure they paid a lot in legal fees on both sides. And yeah.
Yeah, I think the distress between the family too, especially since it was a second marriage, so her son obviously wasn't her husband's kids, that put a little, played a little bit into it as well. But, New York has a statutory form that's used. It was updated only several times over the last, 20 years. It was updated in 2010 and then just recently in 2021. So that was the first time in 11 years that it was updated. So when you do it now, history has shown that it's good. Usually, at least 10 years you have before the form is really updated, unless there's some huge changes in the law. So, if you do it in your 30s and 40s, and if it carries you to your 50s, 60, as you said before, Leslie, if we do another one, then later on, at least it showed what your past intent was. And so nobody could really call it into question. When having an Alzheimer's dementia diagnosis doesn't necessarily mean a person no longer has capacity. All too often, I know for myself, we see clients who come in who have recently been diagnosed and they're fine. They're lucid, they have capacity, they understand what's going on, and then they're getting their planning done. But if you have a child, or especially second marriages like this one, where you appoint your child, but now, and not your spouse, think about 10 years later, and now your spouse needs something, or they're using your money, or your spouse is, nervous, or vice versa, the kid is nervous about their inheritance, their first claim is going to be, oh, well, she didn't have capacity because she had just gotten diagnosed with dementia. It could also even be said for certain illnesses like cancer. Somebody who's recently diagnosed with cancer, maybe they are not really clearly thinking, or if they only have 6 months to live, are they really have capacity to make a decision as to who should take care of them or their finances. So again, planning now, there's really it's never too soon to plan. I think that's the biggest misconception amongst them out there, is people think, oh, I'm young, I'm healthy. No, as soon as you turn 18, you should have a healthcare proxy and a power of attorney.
Yeah, and we talk a lot in estate planning about blended families and how risky they are, and this is a perfect example. I mean, really, the second you get married or thinking about getting married to a second time when you have children from a previous marriage, you should be doing your marriage certificate and your estate planning, because they're just rife for these kinds of problems. So, if you know anybody out there who's getting married, they're going to have a blended family, they are definitely a candidate for estate planning. And as Christina said, no matter how young they are, no matter how much assets they have, yeah. Poor Etta James. I love her. I'm so sad. So if we have any questions, feel free to drop them into the comments, or send us a personal message. Otherwise, we'll be on in a few weeks for our next celebrity estate, and we hope you've learned from this experience to do your estate planning while you're young, especially when it comes to the power of attorney and healthcare documents. And yeah. And for a little bit of money, what it costs to prepare those documents, it saves so much in legal expenses.
And say she's lucky. They're lucky of the outcome that they settled it, even though it took some time and cost. But a lot of times too, when it gets called into question, a spouse or a child just files for guardianship. If it's if it gets called into question, and now you're spending time and money in Supreme Court here in New York to defend it. So it's really important that you have them. So feel free to reach out to us.
Yeah. Thanks, guys. Thanks, Christina.
Thank you. Have a great night, everyone.
Yeah.